Hello dear students, I am Dr. Deepa Dubey. I am Associate Professor at the Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur. Today we will discuss on the topic of burden of proof and criminal law. Before we proceed to the discussion, let us know what are the learning outcomes. First, to make the learners understand the doctrine of presumption of innocence. Second, to make the learners understand the burden of proof in criminal law. And third, to make the learners appreciate the rules of evidence and exceptions thereunder as applicable to criminal law. Criminal law. What is criminal law? Criminal law regulates human conduct. It seeks to protect the state and its subjects from harmful, perilous and antisocial behavior. The criminal law thus specifies various human conducts as offences and prescribes punishments for the same. A person who violates the criminal law and thereby commits an offence violates not only the individual against whom it is perpetrated, but the society at large. The state takes upon itself the responsibility of prosecuting the offender and bringing him to justice. Criminal trials are thus limited in most cases between the state on one hand and the accused on the other. It is the responsibility of the state, that is the prosecution in criminal cases, to prove the culpability of the accused. This responsibility is an arduous one and remains throughout the trial on the prosecution. The premise on which the responsibility is fixated on the state is an age-old presumption of innocence of the accused. What is this presumption of innocence? The presumption of innocence is a fundamental principle of criminal jurisprudence. It asserts that a person should be presumed innocent unless and until proved guilty. It is derived from the Latin maxim, "A incumbet probatio qui dicit, non qui neget." The burden of proof is on he who declares, not on he who denies. Justice Dixon laid down that the presumption of innocence is a hallowed principle lying at the very heart of criminal law. The presumption of innocence protects the fundamental liberty and human dignity of any and every person accused by the state of criminal conduct. An individual charged with a criminal offence faces grave social and personal consequences, including potential loss of physical liberty, subjection to social stigma and ostracism from the society, as well as other social, psychological and economic harms. It ensures that until the state proves an accused's guilt beyond all reasonable doubt, he or she is innocent. This is essential in a society which is committed to fairness and social justice. The doctrine regarding the presumption of innocence has generally come to embody the following procedural elements. 1. The prosecution, that is the state, has the burden of proving all the essential elements or the ultimate facts of the crime charged. 2. The defendant, on the other hand, generally has no burden of proof except perhaps the burden of creating reasonable doubt in the minds of the fact finder as to the strength of the state's case. The defendant may remain silent and offer no defense, relying wholly on the presumption of innocence to carry him to a verdict of acquittal if he is confident that the state has failed to meet its burden. 3. The fact finder should withhold his judgment at trial until all the evidence has been presented and unless the state has proved it beyond reasonable doubt. The rule as it stands thus enumerates that a person who is charged must be proved guilty. In saying that the accused person shall be proved guilty, he shall not be presumed guilty, that he shall be convicted only upon legal evidence, not tried upon prejudice, that he shall not be made the victim of the circumstances or of suspicion which surround him. He shall be convicted, this rule says, not upon any mere presumption or mere suspicion, but he shall be proved guilty by legal evidence, and by legal evidence which is peculiarly clear and strong, that is, clear beyond a reasonable doubt. The presumption of innocence in the administration of criminal justice thus means that the burden of proving the allegations in a criminal case is on the state and the standards for proving the same is greater than mere preponderance of probability, and that any doubts should be resolved in favor of the accused. In this regard, the rules can be found in the Indian Evidence Act 1872, which lays down the precise rules with regard to burden of proof and carves out certain exceptions wherein the burden shifts to the accused to prove the case. What is meant by burden of proof? The burden of proof means the obligation to prove a fact. The term has not been defined in the Indian Evidence Act 1872. It has been taken to mean two different things. It means sometimes that a party is required to prove an allegation before judgment can be given in his favor. It also means that on a contested issue, one of the two contending parties has to introduce evidence. The former is indicated as the burden of proof as a matter of law and pleading. The burden, as it has been called, of establishing a case. This burden rests upon the party who substantially asserts the affirmative of the issue. In the second sense, it indicates the burden of proof as a matter of adducing evidence. The burden of proof in this sense is always unstable and may shift constantly throughout the trial. So, what is the general rule with regard to burden of proof? Section 101 of the Evidence Act illustrates the burden of proof in the sense of proving a case. It lays down that whoever wants a court to give a judgment in his favor as to any legal right or liability must prove the existence of those facts. It is an ancient rule derived from the Roman law, founded on considerations of good sense and fairness. The party on whom the onus of proof lies must, in order to succeed, establish a prima facie case. He must succeed by the strength of his own right and the clearness of his own proof. Section 102 contains the burden of proof in the second sense, that is, the duty of adducing evidence. It lies at first on the party who would be unsuccessful if no evidence at all were given on either side. This burden, however, cannot remain constant but shifts as soon as he produces evidence. It may again shift back to him if the rebutting evidence is produced by his opponent. In an accusatorial system, as in India, the burden of proof solely rests on the prosecution to prove the case beyond reasonable doubt that the accused committed the offence. It is for the prosecution to decide on the evidence it intends to rely on. It cannot succeed just by showing that the defense case is suspicious. where the prosecution fails to prove beyond reasonable doubt the guilt of the accused is entitled to the benefit of doubt. Fazal Ali J. stated the three cardinal principles of criminal jurisprudence in the case of Rabindra Kumar De versus State of Orissa 1977. 1. That the onus lies affirmatively on the prosecution to prove the case beyond reasonable doubt, and it cannot derive any benefit from any weakness or falsity of the defense version while proving its case. Next, that in a criminal trial, the accused must be presumed to be innocent unless he is proved to be guilty, and third, that to the onus of the prosecution never shifts. What are the exceptions to this rule? There are, however, certain exceptions to this general rule as to the burden of proof contained in sections 101 and 102. In particular cases where the burden of proof is cast by statute on particular parties, sections 103 and 105. 2. When any fact is especially within the knowledge of any person, the burden of proof is on him, section 106. And 3. When a rebuttable presumption exists in favor of a party, the onus is on the other side to rebut it. Burden of proof of particular facts. Section 103 of the Evidence Act lays down, if a person wishes the court to believe in the existence of a particular fact, the onus of proving that fact is on him unless the burden of proving it is cast by any law on any particular person. Thus, in a case of theft or receiving stolen property, though the main burden of proof is throughout on the prosecution, yet if the accused sets up a case that he innocently purchased the property, he must prove it. Again, under section 44 CRPC 1973, the public are bound to give information of the commission of certain offences, and the burden of proving reasonable excuse is cast by statute on the person who fails to give information. In a plea of alibi, the burden of proof that at the time of the incident the accused was elsewhere would be on the accused. Under section 105 IPC, the burden of proof is upon the accused of showing existence, if any, of circumstances which bring the offence charged within any of the special as well as of any of the general exceptions or proviso contained in any part of the penal code or any law defining the offence. The Supreme Court has laid down that the burden of proving defences arises only when the prosecution discharges its initial burden of establishing the complicity of the accused. However, the standard of proof which the accused has to satisfy for the discharge of the burden cast upon him under section 105 of the Evidence Act is not the same as is expected of the prosecution, which has to prove the charge beyond reasonable doubt. The burden on the accused to prove his defense stands discharged by issuing preponderance of probability in his favor. The general exceptions referred to in section 105 are those which are applicable to all crimes and are laid down in chapter 4 of the Indian Penal Code, comprising sections 76 to 106. These are specific grounds or defences which exempts an accused from criminal liability. Special exceptions are those which are restricted to a particular crime. Thus, for example, the offence of murder under section 300 of the Indian Penal Code 1860 is a subject to 5 exceptions which are applicable only to that offence and none other. These exceptions to section 300, unlike the general exceptions, do not exonerate the wrongdoer. They only operate as mitigating factors. Thus, if the accused pleads insanity, he has to prove that he was insane at the time of the occurrence. Facts within special knowledge. If any fact is peculiarly within the knowledge of a person and it is difficult for others to know about that fact or prove it, Section 106 Evidence Act places the onus of proof on the person in whose knowledge the fact lies. Where the prosecution proved that the accused took the girl to a lodge and forcibly kept her there, and the girl gave details of what happened there, it is especially within the knowledge of the accused to explain what happened at the lodge, and by remaining silent, he fails to discharge the burden of proof under Section 106 of the Indian Evidence Act. This section is an exception to Section 101. The latter lays down the general rule that in a criminal case, the burden of proof is on the prosecution, and Section 106 is certainly not intended to relieve the prosecution of that duty. Neither Section 103 nor 106 Evidence Act absolves the prosecution from the duty of discharging its general or primary burden of proving the case beyond reasonable doubt. It is only when the prosecution has led evidence which, if believed, will sustain a conviction that the question arises of considering the burden of proof on the accused. This section uses the word especially, which indicates facts that are preeminently or exceptionally within the knowledge of the person. Where knowledge of certain facts is as much available to the prosecution, should it choose to exercise due diligence as to the accused, the facts cannot be said to be especially within the knowledge of the accused. The third speaks of rebuttable presumption. The term presumption may be defined as an inference, affirmative or disaffirmative, of the truth or falsehood of a doubtful fact or proposition drawn by a process of probable reasoning from something proved or taken for granted. Presumptions may be categorized into presumptions of fact and presumptions of law. The former are inferences which are naturally and logically drawn from experience, observation of the course of nature, the constitution of human mind, the springs of human action, the usages and habits of society. Section 114 of the Indian Evidence Act and the illustrations thereunder are examples of presumption of facts. These presumptions are generally rebuttable. Thus, for example, a watch of Ram is stolen and soon it is recovered from the possession of Shyam. There shall be a natural inference, presumption, that Shyam has either stolen the watch himself or received it from some thief knowing it to be stolen. Presumptions of law, they are based on the uniformity of deduction which experience proves to be justifiable. They differ in being vested by the law with the quality of a rule which directs that they must be drawn. A presumption is rebuttable if the law permits the party against whom the presumption is drawn to disprove it. All presumptions of fact are rebuttable, whereas presumptions of law are rebuttable in some cases and irrebuttable in others. For example, 41, 112, 113 of the Evidence Act, Section 82 of the Penal Code. Phipson observes that the chief function of a rebuttable presumption is to determine upon whom the burden of proof rests in the sense of adducing evidence. It means that the effect of rebuttable presumptions is to place the burden of proof on a party on whom the burden would not lie under the normal rules. The presumption has the effect of shifting the burden from the prosecution to accused in criminal cases and requires the latter to give an explanation to rebut the presumption, so that the burden will revert back to the prosecution again. In Lallu versus State of UP 2009, it was held that where a wife dies within 7 months of marriage in abnormal circumstances, the court would presume the death as dowry death, and the burden lies on the accused persons to prove their innocence. The Supreme Court explained that if a bride was murdered within 7 years of her marriage and there was evidence to show that either on the previous day or a couple of days earlier she was subjected to harassment by her husband with demands for dowry, such husband would be guilty of the offence in the language of Section 304B Indian Penal Code, read with Section 113B of the Evidence Act. The husband is liable to be convicted under this section unless he disproves the presumption raised against him. Similarly, under Section 113A of the Indian Evidence Act, where the wife dies by consuming poison and the oral and documentary evidence showed that the accused husband subjected her to mental cruelty, the court held that the conduct of the husband was of such a nature as is likely to drive his wife to commit suicide. Thus, he abetted the suicide and the presumption under the section was held to prevail in the case of Devki Nandan versus State 2003. Under Section 113A, the words having regard to all the circumstances of the case require that a cause and effect relationship between the cruelty and suicide has to be established before drawing the presumption. Therefore, the presumption under the section is not of mandatory nature. Ramesh Kumar versus State of Chhattisgarh 2001. Similarly, the possession of stolen ornaments belonging to the deceased soon after the murder is material evidence against the accused not only on the charge of robbery but also on the charge of murder as held in the case of Gulab Chand versus State of MP 1995. There are many other statutes like the Prevention of Corruption Act 1988, the NDPS Act 1985 or the Negotiable Instruments Act which also create presumptions. However, such a presumption can also be raised only when certain foundational facts are established by the prosecution. It is only in exceptional circumstances, such as those of statutes as referred to above, that the burden of proof is on the accused. Thus, to conclude, the fundamental principles that govern the burden of proof in criminal law may be summarized as under. 1. The accused is presumed to be innocent till his guilt is proved. The burden of proof is on the prosecution to prove that the accused is guilty and the accused need not prove his innocence. In fact, the accused has a right of silence and no negative inference can generally be drawn against him for his silence or failure to lead evidence. The prosecution should prove its case beyond all reasonable doubt. If there is an element of doubt in the prosecution case, the benefit of doubt will go to the accused and he shall be acquitted. In addition to these basic principles, the Evidence Act enjoins certain circumstances wherein the burden shifts to the accused. Thus, the onus of proving exceptions or facts within this special knowledge is imposed on the accused. Similarly, in situations where the law creates a presumption, the burden of proof may shift to the accused. The law does not contemplate that the accused should prove his case with the same strictness and vigor as the prosecution is required to prove in a criminal charge. It is sufficient if the accused is able to prove his case by the standard of preponderance of probability. Thank you. It is sufficient if the accused is able to prove his case by the standard of preponderance of probability. Thank you.